There's an assumption or misconception that a will takes care of everything, when in fact a continuing power of attorney is very important for planning for incapacity. With a will, people think of death as a certainty and may be more willing to think about distribution of their assets on death. With a continuing power of attorney, on the other hand, it handles the distribution of assets, the handling of finances, and wishes being followed while a person is still living and may or may not be incapacitated. People don't like to think of incapacity or mental dementia during their lifetime. It's not always the best or only strategy to put assets in joint ownership, and may in fact not be the right strategy in certain circumstances. Simplicity doesn't always achieve the desired result. Today, many families are blended families, and it may not be appropriate to leave everything outright to a surviving spouse through joint ownership. It may be more appropriate, for example, to leave your estate in trust for a surviving spouse, so that your will guarantees that on the death of that surviving spouse, your estate goes to your own children rather than to the children of your spouse. Also, if your spouse is not competent or is a U.S. citizen, again, a trust in a will should be considered rather than joint ownership. The other thing to note is that putting assets in joint ownership with children may trigger a disposition of an interest in property with tax consequences and may expose those assets to the claims of creditors of the child. There are other ways to deal with incapacity, such as a continuing power of attorney or a living trust. It's very important that the person chooses the right attorney. There's a great potential for theft or misuse of continuing powers of attorney by an attorney, because a continuing power of attorney generally gives very broad powers to a person to make all your financial decisions or healthcare decisions for you, such as paying your bills, but more importantly, having the power to renew a bank mortgage, make investment decisions, sell properties, and in the case of a personal care power of attorney, put you in a nursing home. It's very interesting to note that the law is that someone who has declined mental capacity is able to enter into a marriage, but not able to issue or enter into other financial contracts, such as issuing a continuing power of attorney or changing a will. I have a personal story that I can recount, and I'm sure you've seen articles in the papers. A 70-year-old man remarries and the will is automatically revoked, and upon visiting his lawyer to create a new will, finds that he lacks the mental capacity to do so, which means that the spouse, and sometimes it's a much younger spouse, gets everything in the estate when previous to the marriage everything was being planned for the children of the first marriage. And now it's all null and void because of the remarriage.